Hi, thank you for joining us today. I'm Jonathan Kennedy, and I am a chair-elect and co-programming chair with Krista for the ACS division, CHAL, which is Chemistry and the Law. And I'm presenting today with Krista Bianco, and she is past chair and co-programming chair of the division, CHAL. So we're really pleased you could join us today to discuss the legal qualifications of joint inventorship and some of the ins and outs of that. With that said, the base question I think is really, before we even talk about joint inventorship of a patent, is what is a patent and what do you get with a patent? And a patent is a set of exclusive rights. And a lot of times we think of patents as being the ability to, somebody comes up with an invention, they think, oh, I want to make sure I can do this. Maybe I want to get a patent on it. Well, for you to make sure you can do something, you don't really need a patent. You might need to consider whether or not somebody else has a patent, but you have the freedom to do things. Really what a patent does is it gets you the ability to exclude others. And you can exclude others from making, using, selling, offering for sale, and importing, whatever is patented. And the patented aspect of it is what's in the claims and actually protected by the allowed claim set. And the patent is granted by the U.S. government for a U.S. patent, and there's also patent systems around the globe that you can obtain patents for, say in other countries. And it's set for a limited time. You don't get to have a patent indefinitely. It's 20 years from the earliest filing date of your patent. So maybe you have an invention and you're thinking, oh, maybe we should get it patented. You talk with a patent attorney and they suggest maybe, say, filing something called a provisional patent, which is good for 1 year. It's not examined. It's not a formal patent, but it gets you a place kind of in the line at the patent office and a priority date, a filing date. So you add some additional things, or maybe you tweak a few things on your 1 year anniversary. It's oftentimes called a conversion deadline. You've done some additional testing in that year window and really kind of honed in on what you know you want to move forward with, say, for a commercial product. So you make those changes or modifications to the patent in your claim set, and then you file. Your priority date, the 20-year count, would start from that first filing, the provisional filing date. And that's the time period that you have your exclusive rights. After you have a patent issued, you have to pay maintenance fees in order to continue enforcing your patent, to keep your patent enforceable. It's good for a certain amount of time when you first pay for it, but the U.S. Patent Office, one, likes to make sure that you're actually still interested in keeping that patent exclusive and not open to the public, and so they allow you to pay maintenance fees so that you can have it enforceable up to that 20-year mark. There can be a little bit of additional time added, say if your examination were slow at the USPTO, if there's reasons for the patent, you'd say the patent office had a lot of cases they were examining and your patent examiner wasn't able to turn around and answer things as quickly as their goals are, then you can obtain something called patent term extension. Generally speaking, the patent's good for 20 years, and it provides those set of rights that you see on the screen. And those rights there you can offer, you can ask to exclude people from doing any of those things within the United States. So if you have somebody that's, say, importing something from another country that is in violation of your patent, you don't necessarily get to stop them in that other country from making those things or sending those things elsewhere, but you can stop them from importing them into the U.S. And similarly, the other options here of stopping somebody from making something in the U.S. or using your patented method in the United States, selling patented products. We have an invention here within our company. Who's an inventor, right? And what's joint inventorship? So joint inventorship, what we're here to discuss today, is multiple inventors, right? And the question is, well, what is an invention? So we see this little cartoon here. You got this, this guy, caveman, thinking about something. He's thinking. See the little patents rock behind him, and boom, there's a volcano in the background, and all of a sudden he's thought of this idea of something explosive, some dynamite. Great idea. An inventor is somebody not that just comes up with the idea, but is the person who conceived of the idea, right? So that's that moment of conception that we see right there in the cartoon with the caveman. He conceived of the idea, and it's a full, complete concept of that invention, right? He's not thinking explosion, he's thinking dynamite. And some legal decisions that were issued on this said that the threshold question in determining inventorship is who conceived of the invention. So we go back to that question of where did this come from? And it's not necessarily identifying a problem. Sometimes there can be some overlap between identification of a problem and identification of a solution. So if we realize that there's a problem, say, with something, and that's our idea, it's not that it's the problem itself or whatever we've identified, it's the solution to that problem. It's conceiving of the full invention and then conceiving of it in its fullness. Formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention. So you see, it's that complete and operative invention. And I like this little illustration here because you can see he didn't think of just an explosion, the caveman, he thought of the actual dynamite stick and what that would be. And so now I'm going to have a question for the audience, and I'm going to hand it over to Eric.
All right, thanks, Jonathan. So here's our first poll question of the day. Inventorship of an issued patent is defined by the scope of the patent specification, claims as allowed, claims as filed, or is it examples in the patent?
Say we have a really intelligent audience here because the majority was right. It is claims as allowed. And some people may be thinking of claims as filed. That was the second popular answer. Both of those are focused in on the claims, which is good because inventorship is ultimately defined by the claims. And an inventor is only named if his or her contribution is reflected in the claims of the patent. So somebody at the initial set of filing a patent, when we're thinking about getting inventorship right at that stage, may say, well, we looked at the claims for the application when we filed the application, and these were the specific inventors. And that's correct. That's a proper identification of inventorship at the time of filing. But the thing that needs to be in everybody's mind is that that inventorship can change with the claims during prosecution. And if anybody here has ever worked on a patent prosecution or been an inventor on a patent that's been filed and prosecuted, you'll know that sometimes, you may have had this experience, that sometimes examiners issue something called a restriction requirement, where they'll look at the patent and they'll look at, say, you have 30 claims, and they'll say, well, these 10 claims here are toward a chemical composition, and these 10 claims are toward method of preparing that chemical composition, and then maybe these other 10 claims are toward a method of using that chemical composition. And they say, really, I think that these are distinct inventions. How you make this new chemical composition is different than what the actual scope of the composition is, and then also how you use it is also different. And as a result of that, they may do something called a restriction requirement, and all of a sudden they say you're only allowed to consider in examination one of these 10 claim sets. So either pick the chemical composition to get patented in this application, or pick the method of use, or pick the method of manufacturing. And so then you may say, okay, well, we'll pick the chemical composition and we'll do that. And now you take your claims out for the other applications, and maybe you file what's called a divisional application that's based on your earlier priority date, has that continuity, and based on this application, and you file it with respect to the other two inventions. This chemical composition would be what you're prosecuting at that point. All of a sudden your inventorship may have changed, and we have to go back and say, well, were there people who contributed to the invention who helped conceive of how we're going to use this chemical composition, and who assisted in what we call reducing it to practice, where we go through the steps of we've had a conception, and now we're looking at how to implement that and actually make a real product out of it. There's two parts to inventorship. One is the conception. So having that idea, the volcano goes off, and the man in the illustration had the idea of the dynamite, but then actually going through the steps of trying to make the dynamite, having that span of conceiving of it, and then what the law calls reducing to practice and actually implementing it. If somebody only does the conception but doesn't participate in the reduction to practice, then it's not necessarily that they've actually invented. Maybe they've only come up with an idea. And something that you can do is that person can actually go through experimentation and do it, or they can have constructive performance of it, where they can be, say, they conceived of the idea, and now they're telling someone, the steps, okay, so let's test it this way, or let's try to make the product this way, and then you have somebody who's assisting with the preparation of the product, or maybe a synthesis of a certain chemical useful for making this chemical composition. And then there's the question of, well, is that person who's helping in the lab with the synthesis, are they an inventor because they're participating in this experimentation and reduction to practice? And the simple answer to that initially is maybe not. They're probably not, because they didn't participate in the conception. They're just doing this lab bench work, but maybe they're having problems with the synthesis of a certain component, and then they say, oh, well, what if we did it this way? And they conceive of an idea, and then everybody comes together and kind of works on that conception, and it works together in this experimentation. Then you might have joint inventors in that scenario. We go back and say, okay, well, are all of those things reflected in what the claims are as we're prosecuting it? Say we had this restriction, or we canceled some claims when we remove them, or we made changes to the claims during prosecution. Are the claims as they are now reflective of who conceived and who helped reduce to practice the invention? And that's ultimately the question that we ask. And so then, kind of talking all the way back to the poll answer, it is ultimately inventorship. Proper inventorship is ultimately based on the claims as allowed for the granted application. When you're going to pay the issue fee, you have your granted application, then you say, okay, what is the scope of these claims? Who conceived of this invention that's reflected in these claims, and who helped reduce it to practice, to come to your coalescence of who is actually an inventor or joint inventor. So a couple thoughts on conception. Well, conception has to be complete, right? We have to recognize that the ultimate result desired, you have to identify that. Like, you go back to that caveman, the ultimate result desired was that dynamite stick. And then they have to come through reducing to practice and developing a means to accomplish that result, right? And then you have to be able to do it in a way that somebody else who's skilled in your art, so talking about chemistry, talking about chemical arts, say it's an organic synthesis, somebody else who does organic synthesis reactions would be able to reproduce it. It has to be something that somebody else can practice. And part of the reason for that is it goes back to this public policy idea that we have. If we're going to give a certain person or certain entity the right to exclude others from something for 20 years, the government's going to grant them a right to say that they can sue people and say, you cannot make this, you can't use it, you can't sell it here in the United States. We want to make sure that they are giving something in return. And part of what we give in return is the education of this new invention. It helps progress the arts and sciences by giving a disclosure of a new invention, not just kind of a simple one saying, oh, I conceived of dynamite, but no, if you conceived of dynamite, how do you make it? What's the best way of making it? How do you use it? What's the best way of using it? And fully disclose that, such that somebody else with similar skill and similar education would be able to do the same thing. And so that's kind of the trade-off. You get your 20 years of exclusion, but you also at the same time have now disclosed to the public your new idea, and it helps progress science. So some thoughts here with respect to chemical compounds, and this is, the bottom is a quote there from a case. General knowledge regarding the anticipated properties of groups of complex chemical compounds is insufficient. So say it is a certain chemical, an organic synthesis, and there's a certain compound, and you have some general knowledge about what those properties of those compounds may have. That may not necessarily be sufficient to say that you've actually fully conceived of what this new compound that you're trying to create is. You actually have to have a conception of the specific compound that you're claiming. And maybe, you have some functional groups or branching that you can have, and you have, where there could be some variation, but generally having a sense of what would possibly be in some of those functional groups, or how long might a carbon chain be that you're targeting, with a range in mind. So not just any kind of compound, but actually having some specific thoughts on what that compound may look like. And that's really ultimately, like I said, what defines inventorship is this. Just kind of repeat that because that's a critical point here, is the conception of the invention fully, and then the ability to reduce it to practice and make it, create it, and showing that you've been able to do that so that your invention is fully complete and not just an idea. And the reason for that is that we don't want to keep people from ingenuity by protecting simply ideas. We actually want to push people all the way to having finished inventions that are useful for society and useful for those persons or those companies that invent them. So at this point, I'm going to hand it off to Krista Bianco, and as I mentioned, she's co-programming chair of our division and past chair of our division. Thank you.
Thanks, Jonathan. And Jonathan has explained who can be an inventor, and I'm going to focus then on what does it mean to be an inventor, what rights does an inventor have, and what are some issues if the inventorship is not correct. So first, in the U.S., inventorship determines ownership. The patent law has required both prior to the America Events Act, which was enacted in September 2011, and still after the enactment of the AIA, that a patent application actually names the actual inventors of the patented invention. And each inventor enjoys a presumption of ownership in the entire patent. Outside of the United States, the requirements can vary based on country, but typically applications are usually in the name of the company that the inventors have assigned rights to and not in the name of the inventors. So that is one potential difference in the US versus outside the US. As I mentioned, basically each inventor has an equal, undivided, full interest in the patent unless they've assigned those rights to a company. And in the absence of an agreement to the contrary, each co-owner of a U.S. patent is free then to make, use, offer to sell, and sell the patented invention without regard to the wishes of any other co-owner. Each co-owner's ownership rights carry with them the right to license others, a right that does not require the consent of any other co-owner. And so that means that each inventor can separately develop, market, license the invention, including in the Ethicon case here, where one inventor can license it to a competitor of the other co-inventors. And basically what happened there is the Fed Circuit found that the omitted co-inventor had a right to the patent. And because the omitted co-inventor had previously licensed his right to an alleged infringer, there could be no action for infringement where the omitted inventor refused to join suit. So basically, if one of the co-owners wants to sue somebody for infringement of a patent, they would have to join all of the other co-owners. And if the other co-owners refuse to join in the suit, or that they've already licensed their share of the patent to that alleged infringer, then the other co-owners can't file suit against the other party who they believe are infringing the patent. So ownership is obviously very important to patents. Jonathan talked about the requirements to be an inventor, but what does it mean to be a joint inventor? Basically, joint inventorship requires some sort of collaboration, even if the inventors are not working together. Under the case law, that could be working under a common direction, building on each other's work. Joint inventors must have some awareness of each other. And it could be where they read notes of the other inventor or memos of an earlier inventor, or it also could be suggestions at a meeting. So there's lots of options as to what qualifies as the collaboration that's required, but the cases have found that there needs to be some quantum of collaboration to have joint inventorship. So basically, if two people in a company independently came up with the invention and they didn't have any collaboration or knowledge of each other, they couldn't both be properly named on a patent application as a joint inventor because they weren't a joint inventor as the U.S. patent laws define. And so we have another audience trivia question, and I'm going to turn it over to Eric. But so what's the big deal with inventorship?
All right, thanks, Krista. So the next poll question for the audience today is, a possible consequence of naming improper inventors is, and there are multiple correct answers, or at least there can be on this one. Your choices are reduced royalties on the patent, requirements to back pay inventors not named, invalidation of the patent, or are there no consequences?
Wow, that really shows that our audience is pretty knowledgeable about patent law and inventorship. Each of the three choices that the audience picked could be potential consequences of having inventorship wrong. Obviously, it depends on the facts of the situations, but basically all three of those could be possible consequences. And so the one that I think the bulk of the audience got was that improper inventorship can be grounds for invalidating a patent. And so because all persons who conceived of the claimed subject matter must be named as inventors, if the inventorship is incorrect and ultimately not corrected, the patent will be or couldn't be held invalid. Pre-AIA, incorrect inventorship was a specific ground under 102F to invalidate a patent. The AAA law, which applies to applications that were filed on or after September 2013, removes 102F as a ground to invalidate the patent. But what the AIA did was it basically established derivation proceedings before the Patent Trial and Appeal Board where challengers can seek to invalidate a patent application there. And in those proceedings, if successful, and it was determined that one of the patent applications had derived claims, those claims would be invalid. For issued patents that are subject to the AIA law, a patent owner can also have a limited cause of action for derivation in a federal district court under 35 U.S.C. 291. Obviously, there's still provisions if the inventorship is wrong and not corrected. The good news is that inventorship can be corrected, and the AIA has made it easier to correct inventorship. That assumes, though, that there hasn't been absent fraud or some sort of deceptive intent in the assigning of the inventors of a patent application. So as this slide shows, one bad apple can spoil the whole bunch. Intentional failure to name collaborating joint inventors may result in a finding of unenforceability due to inequitable conduct against the named inventor. And as this shows, that if there's a finding of unenforceability based on the actions of one of the inventors, the entire patent is unenforceable for all of the inventors. And so that is another way that if people have acted with fraud or deceptive intent, that in addition to being invalid, the patent could also be held unenforceable. But as I mentioned, you can correct inventorship. The courts have recognized, and you probably can get a sense of this from what Jonathan has talked about, that determining who conceived of the inventions can be difficult. And so inventorship is recognized as one of the most difficult legal issues out there. And so the patent statutes have allowed patentees to give it the opportunity to correct inventorship either in the patent office or in an action in a district court. So what's on the screen is in the patent office under pre-AIA 35 USC 256A, that would allow, prior to 2011, whenever through error a person is named in an issued patent as an inventor, or through error an inventor is not named in an issued patent and such error arose without any deceptive intent on his part, the director of the patent office may, on application of all parties and assignees, with proof of the facts and other requirements that may be imposed, issue a certificate of correction correcting the inventorship of the patent. And so basically pre-AIA, misjoinder, if there was somebody who was accidentally included as an inventor but wasn't, you could correct that without a showing as to whether or not that mistake happened with or without deceptive intent. However, if somebody was omitted from a patent application or a patent, the error could not be corrected if there was deceptive intent on part of the unnamed inventor. After the AIA, basically, as noted here, 256A had been amended to delete the language in red, and then that basically removes the requirement to prove absence of a deceptive intent on part of an unnamed inventor. So it does get a little easier to correct inventorship. If there is deceptive intent, that can still result in the finding of unenforceability due to inequitable conduct. So they're kind of two separate tests. One is, yes, you would be allowed potentially to seek correction of the inventorship in the patent office, but that doesn't prevent somebody from still challenging the patent in court and saying that the patent should be unenforceable because there was intentional misrepresentation of the inventors. And so this change in 256A was effective as of September 16, 2012. So basically any proceedings to correct inventorship after September 16, 2012 would not need to show that there's been an absence of deceptive intent. And then also what you can do is in court, you can correct if somebody challenges the validity of a patent on grounds that it has incorrect inventorship. A party can seek to correct inventorship through the courts. And basically what 35 U.S.C. 256B says is that a patent is valid if the error has been corrected. And the error of omitting inventors or naming persons who are not inventors shall not invalidate the patent in which such error occurred if it can be corrected as provided in this section. Here, the court may order correction of the patent on notice and hearing of all parties concerned. And so in court, I'm going to go back a slide. So at the patent office, if you would to submit an application to the director of the patent office, to correct it there, you need to have all of the parties and all of the assignees. They basically would need to agree with the correction of the inventorship. And usually, you submit a declaration explaining kind of what happened, who was left off, perhaps maybe that they were inadvertently left off, and that they agree that they are an inventor, Or for example, if there was other people who had been included as an inventor on the patent application and they weren't actually true inventors, then they would have to, the people who were not really true inventors would disclaim that they have any rights in the invention. So basically to make a correction at the patent office, you need to have agreement by all of the parties and all of the assignees that are involved. In court, a court may order correction of the patent basically on notice and a hearing of all of the parties. As you can imagine, many of the court cases, there's disagreement as to whether or not, between two companies, whether or not one of the admitted inventors actually was an inventor or if they were improperly admitted. So that's what the court's going to decide. It's going to hear evidence and decide if that's actually correct. And the standard in court is high. It's clear and convincing evidence, which is a high standard. That's higher than preponderance of the evidence, which is 51%, and that's less than in a criminal court beyond a reasonable doubt. But the standard to prove that the inventorship was incorrect and should be fixed is clear and convincing evidence. In court, it just can't be the word of the admitted inventor. The evidence needs to be corroborated. And so it can be corroborated in a number of ways. It can be corroborated through the testimony of another inventor or another employee. It can be corroborated through notebooks and other documentation. And we'll talk about best practices next in this presentation, and that's some of the things we'll focus on, that really you want to have documentation of ideas and notebooks and work done so that you can have corroboration if for some reason somebody at your company was an inventor and they weren't included as an inventor, you can prove it. And so if the burden of proof is satisfied in the court, the patentee would be given the correction, the opportunity to correct the inventorship, and then what the court would do would order the director of the U.S. Patent and Trademark Office to issue a certification accordingly. However, if the relief isn't sought or isn't granted, if the inventorship is still not correct, the patent could be invalid. So as I mentioned, what are best practices? We'll go into these points in greater detail, but you want to document ideas and experimentation. You want to maintain proper lab notebooks. You also want to have agreements identifying ownership rights. So that could also be a joint development agreement. So when there's a collaborative research agreement, you want those agreements to spell out who owns the IP, what happens to ideas and inventions that come out of that work, who owns it. You want to have contractual language that protects each person and makes clear, if there is joint inventorship, that both companies will be identified as owners of the patent. And also too, you want to have assignments and also employment agreements that talk about whether or not once an employee invents something, that they have to assign all of their rights to the company. So what is an assignment? Assignment means a transfer by a party of all of its rights, title, and interest in a patent application that has been filed. Most commonly, they're from the inventor to an employer, but they could also be from company A to company B. As IP rights get sold or licensed, sometimes the ownership of patents change, and so how you affect that at the patent office is also through an assignment. And if you don't have the assignment, an employer may not have rights in that application, patent, or invention by its employees. Basically, what assignments you want to be in writing, and you also want to identify the patent or the patent application. You want to identify the assignors, identify the assignee, and you want to have it in English. The Patent Office will accept and record non-English language documents only if they're accompanied by an English translation signed by the individual making the translation. You want to record your assignments with the Patent and Trademark Office, and that provides notice and rights that you have the assignment. In addition, it's a good practice in the employment agreements to have language that employees will agree to and hereby grant and assign all rights and future inventions falling within the scope of the employment agreement. That way, that if for some reason you haven't executed an assignment, there will still be contract language protecting the company saying, well, there's no doubt that the employee, that we own the invention, the employee just has to assign it to us. And then as Jonathan mentioned, inventorship can change as the claims go through prosecution, and inventorship depends on the allowed claim. So it's as an application gets allowed, you want to confirm inventorship of the allowed claims at the end in case that there has been changes in the claims, and that means that different people are an inventor or are no longer an inventor. Some general considerations, as I mentioned, inventorship is very difficult and it's very fact specific, but things, working with a patent attorney or people that are involved in that determination, what to take into effect. Who contributed to the complete concept of the invention as defined by the claims? Jonathan talked about, the synthesis of compounds, but even too for compounds, and if you're filing a patent application that claims particular uses of those compounds, who developed specific screening concepts, who identified trends in the data that led to a recognition of the claimed concepts. Are those things that actually are part of the invention and that those other people should be included in the application other than just the people who discovered or made the compound? Who contributed to reducing the invention to practice? Was that contribution independent? Was there some special technical skill required to reduce it to practice such that really is part of the conception of the invention, or was the technician merely doing the work under the direction or control of another? Did the technician have the synthesis of how to carry out and make the compound, and so they were just really making the compounds? They didn't have any intellectual contribution to the conception or the reduction to practice. And as we've talked about, you want to consider each claim of the application. An inventor only needs to contribute to one claim. So to be joint inventorship, while there has to be some requirement that there's some collaboration, it doesn't mean that people have to have equal collaboration or contribution to the claims. To be an inventor, you only need to contribute to only one of the claims, and so therefore differences in timing or place or amount of contribution really do not matter for purposes of determining inventorship. And so more details on what are some best practices for lab notebooks record keeping. You want the lab notebooks or records to demonstrate authenticity and reliability. So you want the details of the work or the idea conducted to be within that notebook. It's best practice for the notebook to be permanent, complete, and continuous form. Nowadays, e-notebooks are getting more popular and being used, but if you have a physical notebook, you want a bound notebook with consecutively numbered pages. Also, date the ideas, date when the ideas were formed, the work conducted, completed, include protocols, designs of the experiments, results, data. And you really want, because it's corroboration, you really want the laboratory notebooks to be signed and witnessed. So you want each entry to be signed and dated, and you want the witness to be able to understand what's on the page. And so maybe the person who's the witness on the notebook page can also be a corroborating witness in a court proceeding if needed, if the notebook isn't enough. And so if you're an inventor yourself, what can you do to help capturing inventions and make sure that you're rightly included as an inventor when you invented something? First and foremost, it's up to you to invent. So you want to invent, and then you want to follow whatever procedures you have at your company for identifying inventions. So that a lot of companies use invention disclosure forms, that sort of thing. And a lot of companies also have the IP attorneys are part of the discovery, part of the people doing research and development. So they have an idea of what's going on, maybe what are inventive ideas, what new and exciting has come out of it. So it's always good, I think, to have a dialogue with your patent attorney. I know Jonathan and I really enjoy working with inventors and people doing work. We're not scary people, so reach out and talk to your patent attorneys. Also, you want to assist your legal department and outside counsel in understanding and identifying inventions. Usually the patent attorneys draft the applications, but you want to make sure that they're clearly conveying what the invention is in that patent application. And then also you want to review drafts and also the final patent application to make sure it's correct. Basically, when you are an inventor on a patent, you will need to submit an oath to the Patent Trademark Office saying that you've reviewed the application and that you believe that you are an inventor of the subject matter of that patent application. And so that's under perjury, so you want to make sure that you can say that accurately. And as I've been talking about, you want to sign the oath and declaration that attests to being an original inventor, that you've reviewed and understood the contents of the application, and that also inventors have a duty before the Patent and Trademark Office to disclose anything that might be material to the invention. So if you have knowledge of prior publications, that might be prior art, or other things that you have a duty to bring that to your patent attorney or bring it to the Patent and Trademark Office. And then also you want to make sure you assign your rights to your company. For example, if your employment agreement requires you to, and that's probably for companies, you want to do that. You want to actually get the assignment and record it pretty promptly or around doing the patent application, because over time people leave the company, people unfortunately get sick or maybe pass away, and so if you promptly get the assignment of rights, it can eliminate a lot of issues or difficulties down the road with making sure that the inventor's rights are assigned to a company. That's basically the overview that we have. We're going to open it up for a question and answer now, and I'm going to turn it over to Eric.
All right, so before we go to that live Q&A, I just want to thank you, Krista and Jonathan, for teaching us about joint inventorship. The ACS Chow Division focuses on educating others about issues that arise at the intersection of chemistry and the law. Make sure that you catch all the past recordings from the series, which are housed on the ACS Chemistry and the Law Division YouTube page. And with that, Jonathan, what's the first question?
A question from someone emailed in at the start of this, and it says, I did polymer chemistry R&D for many years before evolving into a statistician. As a consultant, I sometimes come up with potentially patentable ideas that my clients can use. How should that sort of thing be handled?
Hopefully, I think Jonathan's mic was breaking up, but basically, just to repeat the question, was that a consultant wanted to know that he comes up with potential patentable ideas, and what should he do about that. I think as a consultant, this is where you want to make sure the consulting agreement addresses what happens to ideas that come out of the work you're doing for the consultant or for the company, who owns it, who has rights to it. Sometimes it could be both the consultant and the company, but then maybe sometimes as part of doing the work, then it's decided that the company would have rights for it. So you want to try to anticipate these things in the agreement. I think that's a good first step to eliminating some of the disputes. And also too, I think if you have an ideas too, you want to maybe talk with a patent attorney, because it can be difficult to maybe identify who an inventor is. So is the idea you have really that complete conception and an invention, or is it a preliminary idea that led to other work that actually then resulted in the conception of the invention? So I would also encourage consulting with your patent attorney as well if you think you did have an idea that led to something as well, to make sure that you were an inventor on it if it's proper for you to be so.
This is Jonathan. Just want to let everybody know I'm back on. Hopefully you can hear me loud and clear.
Yes, we can, Jonathan. Thank you.
What I was saying is that we had a couple different questions dealing with digital notebooks or e-notebooks, and so I thought I'd kind of group those together for answering. And so one was, what are some guidelines for e-notebooks? And another was having notebooks signed by a witness, and is it possible to have digital notebooks, or must they be paper and ink to provide for the signature? So maybe we can address those together, some general guidelines for digital notebooks.
Yeah, I'll start, Jonathan, and then I'll turn it over to you for guidelines you have. I think e-notebooks, like everything else, are gaining popularities, and so I think you just want to make sure that they're going to be reliable. And I think you can still have a witness e-notebooks with signatures or other things. So I don't think nowadays they have to be bound. It's just, I think it takes a while for the case law to kind of catch up where technology and where companies are going these days, where more things are moving online as opposed to being in paper. I don't know, Jonathan, do you have thoughts?
Yeah, and I think that there's some different approaches that people can use sometimes to digital notebooks where there can be review. I know I have a client who has one, and they have the ability to have, like, once a notebook page is filed, somebody who can then review it in some sort of check mark, of signature, or some way that would be similar to, the prior time period where we, work in a lab and then have our notebook, fill it out, and have somebody else there sign it. But they had a provision where, like a lab supervisor or somebody else from the lab could also check off on it, so that it provides some of that same affirmation of this is actually true and accurate, happened at this time, to kind of prevent people from saying, oh, we created this at this time, and it turns out it was actually later. And in some respects, the digital notebook can actually give you that earlier date, because oftentimes there's metadata associated with the notebook itself, in that it shows a time and date stamp that is more difficult to change as opposed to a physical notebook where you could write in it and write whatever date you wanted to write if you were trying to show that it was from earlier than maybe your inventive activity really was. So another question we have is, if the first to file is now the rule under the AIA, what is the relevance of inventorship?
As I mentioned, both pre-AIA and post-AIA, there's still the requirement that a patent application lists the inventors. So that still stays true. What the AIA did is it also provides certain advantages for being a joint inventor because it removes certain prior art. And so, basically, if an inventor of a related subject matter is named as a joint inventor, that would remove some publications as prior art. And also, the AIA also would remove disclosed subject matter claimed inventions as prior art if they're commonly owned or subject to common assignment by the time of the effective filing date. So there's advantages there to being a joint inventor, or even to having a patent under common ownership.
We have a number of questions addressing issues of co-inventors or research teams, or possibility of somebody being in a supervising role, and some of that kind of soundboard position that people can sometimes play where, somebody's doing work in a certain area and they maybe go talk with some others, maybe a supervisor, bounce some ideas off their head, and then somebody may sometimes give some feedback that says, hey, maybe you should try using this chemical, or maybe you should try taking this synthesis approach. One of them kind of sums it up, I think, in saying that I'd like to know more detail about co-inventors where one conceives the idea and others from a team reduce it to practice. Can you give some examples of this? And I think if we can maybe contrast that, giving examples of that, but also with examples where the whole collaborative team maybe all participates, so we can see the distinction between the two.
I can throw out some ideas. So if somebody is merely recommending a material, or saying maybe try this chemical, but there's a lot of different chemicals that do the same thing, or all of it was known in the prior art, that suggestion isn't an inventive contribution. I think basically it would have to be an idea that was not already known in the prior art or common knowledge that you're really contributing to the invention. And if that person is contributing that, then potentially they could be an inventor. So for example, I mentioned in the previous slide, who came up with the screening strategy, and was that screening strategy really responsible for identifying the compounds that were ultimately found to be useful, or identifying the promising compounds, then that would be a contribution. Or for example, if there were certain trends or data points that the rest of the team wasn't getting, but somebody else noticed something and raised it and said, hey, what about this? And then that led to a discovery of a new property or new compound, or really, allowed the invention, then that might be another example of something that would be a contribution to the conception to qualify as an inventor. I don't know, your thoughts?
No, I would generally agree with you. I think the part of it is, highlighting kind of what you said in the beginning there is it something that's common knowledge and a routine thing to say, oh, well, did you try doing this kind of a test, say to demonstrate that you actually synthesize something, or the existence of a particular property, or whatever it may be, versus actually conceiving of part of the inventive idea and saying, well, maybe including these things is the answer, and those are maybe not just routine, and they're actually novel things. Then I think that's a big consideration in the determination of that soundboard role. Is everybody an inventor, or when somebody actually is helping conceive and helping reduce to practice?
I was going to say, I think that is a struggle where a lot of times you have more junior people that might help be carrying out, making the compounds and that sort of thing, that there is always that tension as to, did they do enough? Did they do something that makes them an inventor, or really were they just following procedures and instructions from their supervisor? So this is really, I think, what's the difficult part of identifying proper and correct inventorship.
Yeah, and I was going to say, kind of making a plug for the patent attorneys here, is these are great things to discuss with a patent attorney, whether that's an in-house patent attorney at a company or an outside patent attorney that you're possibly working with. But when patent attorneys are oftentimes interviewing for new invention records and talking about preparation of an application, they may ask a lot of questions about who did what and why. And part of it is to get some of this information, and it's hard to tease that information out, but it is important. And the inventorship rules, as we learned in this webinar today, are different than, say, the kind of information that you would see on a typical journal article regarding who contributed or who's an author of a journal. I mean, it's a very distinct kind of category, and the law is fairly specific in a kind of ambiguous way, right, with this idea of conception and reduction to practice for what that means. But if you have thoughts on it when you're working with a patent attorney, you know, convey the information as much as you can regarding who did what and who came up with things, or document that, as Krista suggested, because that can be helpful down the line.
Because usually in a publication, sometimes for political reasons or other things, there's a lot of authors on the publication, and there's really no ramifications if you're over-inclusive. But as we've talked about today, there can be serious consequences if you're over-inclusive on a patent application. So you really want to make sure that the inventorship is correct.
Absolutely. Another common question that we have is dealing with assignment. In the effective assignment, saying in one place we had a question asking, when there's questions about who contributed within a company, does it really, you know, if we're not sure who's the actual inventors or if somebody was contributing in an inventive way or a non-inventive way, does it really matter because everybody assigned their rights to the company? Then there was another question similar saying, what if a company agrees to pay an employee for their inventions, and then the employee assigns to the company, who owns the patent if the company never assigned? So I think kind of trying to deal with assignments and remuneration or payment for assignments, or the effect of, you know, identifying inventorship when ultimately the company ends up owning the IP anyway.
If the inventor never assigns it to the employer, then the inventor would own the patent application unless there's an employment agreement that has sufficient language that I guess the company can prove that they've, in effect, through that employment agreement, have assigned any inventions that they came up with to the company. So I think as people are named on a patent application and as it gets filed with the USPTO, I think it's a good practice to execute an assignment, even if there's already an employment agreement or something else establishing the assignment, so that there are no issues, that the rights have been fully assigned to the company and the company owns it. And then say down the road, if it turns out that the inventorship needs to be corrected or somebody else was omitted, then you could execute the assignment when you correct the inventorship or add that other person to the patent. And hopefully, because of the employment agreement that's in place, that there's no issues. That I think it's, in a lot of companies, most employees expect that they would have to assign their rights to the company. So I think that's a best practice for, you want to always execute the assignment, because that's a protection and a necessary protection that's helpful. And if you don't have that, I think it's creating a lot of problems that can necessarily be avoided. And then, I'm sorry, Jonathan, within a company, if basically everyone owns it?
Yeah, if everyone's already assigned it, that was another question, is if everyone's already assigned it and say there's some ambiguity maybe regarding who the inventor is, does that really matter, since everybody's actually kind of given their rights, who might be a contributor, given their rights to the company already?
Oh, I mean, practically it probably doesn't matter because the company owns it. But again, as we've talked about, you want to make sure the inventorship is correct. And then I would have assignments for all of the people who actually ultimately end up being inventors, just out of an abundance of caution.
Yeah, and I would agree with that. Something that just came up too is with our discussion of assignments was, are assignments covered by local law? What happens in the case of foreign inventors?
That's a good question. I think that might be a little more complicated than we have time to answer. I see that we're running out of time. I believe you usually have a U.S. assignment, and that U.S. assignment can be effective outside the U.S., but then also usually it's a best practice to get a worldwide assignment. So, you know, the language would be any application stemming from the first filed application, and if that first filed application was in the U.S. So that's one way to deal with the assignment, to briefly answer the question.
And one other comment too is that generally, you know, assignment is a type of contract, and contracts are generally construed under local law. So yeah, state law oftentimes governs, say, an employment agreement with an assignment, or there could be assignments that are separate from that. It doesn't mean that you couldn't enforce in state, you know, in federal court potentially. You might be able to enforce an assignment in federal court as well, to do with patents. But generally speaking, it'll probably be subject matter to a local law within the United States it's a contract to sell somebody or to give the property away.
We wanted to thank everyone who really joined this 5-part series that Chow has offered, and it's something that we hope to offer next year, and so we encourage everyone to keep their eyes out for announcements of the next series. And also too, in the feedback, we've gotten a lot of feedback for other topics that people are interested in, but if you do have a topic that you think would be of interest in the next Chow webinar series, to please send me an email, and that's something we can take under consideration.